Thank you, Your Honor. Before the court is Jessica Ash of case 2-1. Ms. Ash is here today after failing to appear before referee Snyder on October 25th, 2022. Bond is currently set at $690. This is the second bench warrant. She reports no employment. The last payment made on this account was in November of 2022. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on February 15th, 2023 at 8:00 a.m. before this court.
Ms. Ash, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would allow you to release pending that hearing on February 15, 2023 at 8:00 a.m. Are you able to post the bond?
I got $11 to my name right now, $11 right now on me. I can give you that $11, please. I literally will come up to the courts and I will get papers to do what you need me to do. I've been trying to find work again. Please.
Okay.
If you guys can work with me, I can work. I can do my best. I can do better, please. I didn't know I had court on the 25th of October. I'm being honest.
Yeah.
Otherwise, I would have.
Well, what you have to do is you have to keep your address on file with the front of the court. If it changes, you have to notify them, or otherwise they'll send it to the last known address. What the court's going to do is I am going to reduce your bond in hopes that you'd be able to be released. I'm doing that because it is your second bench warrant. I'm going to set your bond in the amount of $200.
I don't even have that.
If you're able to post that, you'd be able to be released.
I don't have that, sir.
Okay.
Please, I only have $11.
Okay. Well, unfortunately, then, ma'am, you're going to have to remain there until February 15th when we have your hearing.
I have doctor's appointments and stuff, sir, please.
Well, that's a really reasonable bond. I'm sorry that
I don't have it.
I understand you don't have that, but that's what the bond is set at. So I'm sorry, and that if somebody can't post it for you, then you'll
I don't
remain.
have anybody's phone numbers. I don't know.
Okay,
Please,
thank you.
Sir.
We're going to we'll end this hearing at 8:38 a.m. You're free to go. Thank you. Thank you. Mr. Clark, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on February 15, 2023 at 8:45 a.m. Are you able to post a bond, sir?
Not at the moment. I don't know. I might, but I'm not for sure right now.
Okay. Court does note that it is your fourth bench warrant and you've never paid any support in this case. So
these are rearages that I didn't know nothing about for a long time. I was locked up. I did a year and I wasn't even supposed to pay this child support. I don't understand why it hasn't been dropped yet.
Well, you're going to have to, when you get out, you're going to have to take care of that and try to get it dropped. Then you just can't ignore it and let it sit there if it's something that should be taken care of. What the court's going to do is I'm going to reduce your bond, but set it in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions? Ms. Reed, on behalf of plaintiff, Ms. Gatt, on behalf of the defendant, we're here before the court on the defendant's verified motion to set aside default and request for mediation. The court had previously stated and acknowledged, as Ms. Reed had stated in her answer, there was an acknowledgement of service signed by the defendant in this particular matter. So, Ms. Gatt, how do we get past all that?
Yes, Your Honor. Thank you. I unfortunately was not aware of an acknowledgement for the complaint or a signed acknowledgement for the complaint being provided to plaintiff's counsel. It doesn't negate the fact that there is a motion for temporary orders that was mailed first class and the notice of hearing that was mailed first class. And by the time my client received it, it was after the hearing date. It also doesn't negate the fact that the parties were cooperating extensively prior to any default order being issued. A good example of this is the marital home was already sold and the proceeds were already divided. The 6-month statutory waiting period has not expired. I believe it ends in February. There is no additional expenses that plaintiff has brought upon if the default motion is set aside. The purpose of a default is to give the defaulted party an opportunity to move to set aside the default. As soon as my client received the motion for temporary orders and the notice of hearing, and then following that to the interim order, he went and sought counsel. When he was in the middle of seeking counsel, that's when he received the default that was issued on December 8th, 2022. As soon as he officially secured counsel with my firm, we filed a verified motion to set it aside. I have reached out to opposing counsel to try to set it aside, and my client just wants to come to a resolution. I think a mediation could resolve any outstanding issues. When he did receive the interim order, there are issues with the physical custody and parenting time stipulation in the interim order that we feel can be resolved through a mediation and just to keep this process going forward. If the court doesn't feel comfortable granting a default, I still ask that there be an order for mediation and to allow my client some discovery to make sure that any proposed judgment of divorce has all the assets from both parties represented in that proposed judgment of divorce. My client does not know all the details for Mrs. Spence's new employment. So that's something we would want to come out in discovery. We do feel that all this can be resolved with
Your
mediation.
Honor, the service in this matter was more than proper. He did sign that acknowledgement way back in September. We properly noticed him of the motion hearing. He did not appear. I spoke to him prior to the motion hearing. So there's no secrets here. So MCR 2.603 D1 states there has to be good cause or a meritorious defense, actually good cause and a meritorious defense presented in order to set aside a default. We don't think that they've shown any good cause or any meritorious defense. So that's an issue. The result of mediation is not going to be dissimilar to what this order already states. These parties have been separated for over 2 years. My client lives with the children in Marshall and always has. The defendant lives in Holt, an hour away. And so we don't think that mediation is going to produce any real difference in what any default judgment would have. I understand that this court may be inclined to move that default aside. And if that's the case, I would draw the court's attention to 2.603D section 4, which states that an order setting aside a default must be conditioned on the defaulted party paying taxable costs incurred by the other party in reliance on the default. And so we would ask for attorney fees, not only for answering the 31 paragraph motion, which frankly, was filled with inaccuracy and outright lies. So that's a problem. Also for attending this hearing, and also the cost of mediation. The real issue is that the defendant doesn't want to pay child support. That's why we're here today.
3.210B2D, and I stated this in my motion, does allow the court, even if the default is not set aside, to allow the court for the parties to go to mediation, to allow discovery to go through, and for my client to have that legal process and to attend hearings. So if this court isn't inclined to set aside the default, I'm asking to utilize that and to still have the mediation, to still have discovery. There are issues that can be solved in mediation. For one, the parenting time schedule does not have an exchange location. It does not have which party is transporting the minor children. This is becoming a continuous issue between the parties. This is something that could easily be solved in mediation, but it's not being solved outside of mediation. There hasn't been extensive costs to plaintiff. I think there was one subpoena that was sent out to my client's employer. And as soon as I got the information, I also made sure Attorney Reed had that information for any employment expenses, anything that could be used in the divorce. Child support is not an issue with my client. He does understand paying child support is the right of the children. He doesn't contest that, but it hasn't come up. It's more just about making sure that the parenting time and custody order can be something that the parties can be followed. And my client disagrees with the parenting time schedule in place and wants a different arrangement in place that could easily be resolved in mediation if we sat down for a small period of time to get an order that's more conducive to the parties' living situation, something that specifies a parenting time exchange. It specifies which party's transporting when. Right now, the current order just says my client should have parenting time on Wednesdays, and there's other weekend provisions in there, but using that Wednesday as an example, it says my client should have parenting time on Wednesday. Well, where are they meeting? Because there is a distance in between the parties. Who's doing the transportation? These are issues that I think could come out during a mediation and create an order for the parties to move forward that is in the best interest of the children. It has not been an option on the table until now.
Okay, well, obviously, it sounds like some of those issues are pretty minimal. I mean, but the court notes after again reading the pleadings and hearing the argument here, the court does not believe that there is good cause to set aside the default. The court will allow the default to remain in place. The court, however, will allow the defendant to participate as it relates to disputed matters, which again makes obviously mediation appropriate. The court will set the matter for mediation in March. The court will, in this case, allow Ms. Reed to again, and I will award taxable costs. Ms. Reed, you'll have to prepare again that affidavit and state what those costs are, and we'll have to address that at a subsequent hearing in the event that Ms. Gatt does dispute that.
Judge, when you say taxable costs, would that include the cost of mediation?
No, because if, again, it's another process, but it's not necessitated by, again, the default in this case. So it'll be your cost for the default, noticing up, if you noticed up a judgment, I don't know if you did, and preparation of that judgment, as well as a hearing. Plaintiff's motion reference to custody. There was an order entered from a referee hearing back on October 24, 2022. Ms. Guerin, that order did include a provision that said you had a right to request a judicial hearing within 21 days from the date of service of that. Service did occur on 10/24/22. So your motion is not timely as it relates to the referee's recommendation. What's your position, ma'am?
Okay, I do apologize. You were froze for a minute there, Your Honor.
Did you hear what I said at all or not?
I heard the part where the judicial hearing on 10 and being served.
Yeah. What happens, you were served on, the order came out, the order was dated 10/24/2022. You were served on the same date. It provides that you have a right to request a hearing within 21 days of the date of service. You haven't requested that within the 21 days, so your motion is untimely. What's your response?
Your Honor, there is actually a motion. We did do that. We have it adjourned because I am waiting for the transcripts. I actually, just from now your court, did not receive the request after I've sent it 3 different times. So I am getting the proof that I have sent that request to you, the courts, for the court records. And so once I was instructed by yourself that once we got the records or the transcript, excuse me, then we would reschedule that hearing. So I did do that. But this motion is really emergent at this point, and that's why I did it, because of what the father is doing to this child.
Okay.
And
again, it gets back to the thing is I cannot make a determination on what the referee did until I have a transcript to see what the referee did and what they based it on.
So that's why I'm asking you to look into this information, because this is new information that the referee did not have, because this is new coming from that. So I'm asking to have it re-looked at, the motion regarding custody.
Okay, what I did is I looked at your motion, and it seems like most of the allegations predate the order, though.
I'm sorry.
Your allegations in
You
your
bleeped out,
motion
Your Honor.
appear to predate the order.
No, there are several of them. Yes, in the beginning they were, but after that, it has been since then. In January, things of that nature. There are several things that have happened after the order, such as her progress reports, text messages, things like that. So yes, there's a few of them that mention the order previous,
Okay, what happens,
but it's
ma'am?
mainly after what's happened.
Each time we review one of these, you can't go back and predate, the order, okay? If you do, like in this case, when I read it, it just appears to be very confusing. So if you address in your motion only things that happen after that motion, then the court would have an opportunity to give it appropriate consideration. But you can't when you go into and dredge up everything that predated the order, because it's just too
Okay,
confusing.
so, and I definitely understand that, Your Honor. So that would take out basically 1, 2, and 3. That is it. It's everything after, everything else has happened after.
Okay,
So I do completely understand what you're saying, Your Honor, and I do agree, and I understand that. But it's mainly everything that's happened after. In the order mentioning the doctor, so I mean, it's everything after. It's the
Okay,
lack of her medical
okay.
care,
I've
lack of
got
her
it.
schooling.
Let me tell you, I've got a ton of hearings on this, so
Yep.
summarize quickly what the salient allegations are.
So, and I'm gonna, and very quick without what you're going, but real quickly, the medical allegations, he is, her eyes have depreciated down by 50%. She needs to see a pediatric ophthalmologist. Her father refused to help her find her glasses to give her the.
No.
Okay, hold on, she's making her allegations. You can respond in a minute, sir. Is this the child?
I'm his wife.
No, sir.
Oh,
no,
okay, okay.
no. Sorry, sir.
Go ahead. Ms. Karen, go ahead.
My apologies. I'm not sure what you heard. So this child has created possible acid reflux or ulcers. She does need to be seen by a doctor. Her father's refused to follow her food allergy of that nature, and it's with her has taken an old allergist reports that are not accurate. So we have her medical needs are being neglected. Her father feels the need that is safer for her to be involved into family adult drama with my family instead of protecting her after I've repeatedly asked her. So this child's mental stability is very unsecure at this point. I have asked him repeated times to stop in my family. I alienated myself. I don't speak to my family. And her father feels the need to keep this child involved in the drama, tells her to keep secrets from me in regards to my family. That is not okay for an 8-year-old. This father is more worried about this 8-year-old girl having a boyfriend than he is about her education. Lily has informed us that she is afraid of her dad. She has brought up her stepmom, and she says she loves her stepmom. Her mom protects her. Most recently, which is not in that order, I need to do an amended one. It happened over the weekend where the father.
Ma'am, don't bring up anything that happened this last weekend. It's not in your motion.
Okay, well, part of it is in my motion. So I was just bringing up, so I apologize. But her cleanliness, her physical health on top of it, her cleanliness is at risk at this point. Along with the living conditions, space heaters in bedrooms.
Okay, let me have Mr. Samuels respond.
Let alone the parent.
Okay.
Okay.
Mr. Samuels, you have to unmute yourself and then respond, please.
Yes, sir. I did not know that Lily Ann's glasses were missing. I do handle Lily Ann's day-to-day functions. I do take her to school in the morning, sir. Also, as well as Lily Ann's education, there is a reason why I have the custody of Lily Ann, sir. There were
Sir, I'm not getting into any of the history of this. I only want as it relates to the current situation.
There is no concerns on my side. Lily Ann has said something to me just recently about acid reflux. I am scheduling her a doctor's appointment, sir. I do meet all of her needs when I am asked about them.
Okay. Have you kept the plaintiff informed of those medical appointments?
Sir, I have just now heard about acid reflux today. I have been talking to Lillian. She has not said anything to me about this. Lillian was taken to the eye doctor by the mother, and I was not notified of this until it came through in this order, sir, which is one thing that I had that me and Christina needed to talk about. Other than that, sir, I have not been made aware of anything, but I will schedule a doctor's appointment for Lillian ASAP, sir.
Okay, fine.
Yes, so Mr. Samuels knew about the eye doctor. She is scheduled every year. The school brought up issues with him in regards to the eyeglasses. His theory is Lillian needed to grow up and find them. As for the acid reflux, Lily explains to us that they pop her full of the medicine that she said her grandpa uses, which is Rolaids. My father uses Rolaids quite often, and that's why she quoted her grandpa. So I feel that they were aware. He has been made aware of her food allergies and has refused, and that's documented in the foster care cases, things of that nature. As for the glasses, Mr. Samuels sent me a text, and I believe you guys have a copy of that text message where he said, thank you. It came through on insurance. I never used insurance. That was money out of my own pocket. The idea's been behind.
That's irrelevant, ma'am.
Well, the idea behind it has been that I pay for the glasses at my home. He pays for the glasses at his home.
Irrelevant, ma'am. That doesn't address the motion. Okay.
Well,
what the court's going to do, obviously, there's a lot of complaints in this particular matter. However, based upon the complaints, the court doesn't believe that they raised to the level of proper cause or change in circumstances to reach the level of the threshold in Vadvarka. There's disputes, obviously, but the court does not see any reason to revisit the issue of custody in this case. Okay. And therefore, the court is going to deny the motion. Mr. Samuels, you can prepare an order denying the motion and submit that under the 7-day notice, okay?
Yes, sir.
Okay.
How do I argue your ruling, Your Honor?
You're going to appeal it to this Court of Appeals. This matter is concluded at 11 a.m. You're free to go. That.
Because this child is at risk and the
hearing is over. The hearing is
Thank
over.
you.
Court will note the appearance of Mr. Jordan on behalf of the prosecutor's office in this matter. We do have two matters. As staff had stated, there was the defendant's motion to terminate the personal protective order and the petitioner's motion to show cause. What I'm going to do is start out, Mr. Black, Ms. Johnson. I'll have both of you sworn in. So if you would raise your right hands, and then we'll take some testimony. Okay, thank you. Why don't I leave this, Mr. Jordan, I'll let you proceed, and then we can get testimony as we go, and that way might be more efficient to do that than have parties rambling.
Okay, Your Honor, and I'm basically here just in regard to the show cause that was filed by Ms. Johnson.
Understand.
Okay. And then Ms. Johnson, well, and I guess before we got started, I would just ask the court to take judicial notice that the PPO was properly served on December 7th, 2022. And that is when Mr. Black received a copy of the PPO.
Okay. Mr. Black, are you disputing that you received a copy of that PPO?
No, sir, I'm not.
Okay. Go ahead, Mr. Magnuson. The court will take judicial notice of its file.
All right. Thank you. Ms. Johnson, back on December 30th of 2022, there come a time when you saw Daniel approach either your vehicle or was near your home?
It wasn't my home. It was my boyfriend's home. He followed us.
Okay. And what happened on that day? What did you see?
I seen him run into his car, jumping into his vehicle after he slashed 2 or more of my tires.
Okay. And did you see him buy your car?
No, I didn't see him buy him my car, but my boyfriend did.
Okay. And so when you saw him running away from your car?
Yes, I heard the pop. I jumped up, ran to the door because I've been having so many other times my tires been slashed. So we was watching my car.
Okay.
We was watching it. So when we heard the pop, we ran to the door. I ran to the door.
And then you saw.
Yes, I see him jumping in his car, making a right on South Ave and then a left on Dickman, going towards his home.
Okay. And so does Mr. Black live anywhere near your boyfriend's home?
No.
Okay. And then I want to direct your attention to January 6th of 2022, or I'm sorry, 23. So literally a month ago. Were you doing something different with your vehicle at that point than you normally?
Yes, I was hiding my car. I was parking my car somewhere else, getting a ride home. And this day, I parked my car, and when we was walking to the store, we observed Mr. Daniels on 20th Street, on Goack Street, about to make the right onto the side road by my street. But when he seen me and my boyfriend walk to the store, he kept going straight up Goack Street. Okay. By the time I went in the store and came out, I observed him coming out on 22nd Street, making a left up Goack Street, going back towards 20.
Okay. And so how long were you in the store? Not
even a minute. It wasn't long. We went to the front counter, got what we wanted, and we came right back out.
Okay. And so when you came back out, was Mr. Black's car like going in a continual path when you first saw it, or did it seem that he was circling the block?
It was like he was circling the block.
Okay. And did he approach you at that time?
No, he did not.
Okay.
I think he was looking for my car because he ended up finding it on the 9th when I had 2 more tires slashed.
Okay, and that's where I'm going to next, is then on January 9th, 2023, there was damage again to your car, is that correct?
Yes.
And where did that take place?
That took place at the spot that I had my car parked at, which wasn't far. It was literally like in the next parking lot, but it was hidden. He didn't see my car for like almost 2 weeks. And then I'm guessing after that night of circling around the block, he found my car.
Ma'am, don't guess or surmise. Tell us what you observed, okay? You're saying,
okay,
oh, he must have done this, or he, and if you can't testify to seeing him do something, don't testify to it.
Okay, well, I didn't see him do that, but of course we know it was him if I caught him the time before doing it.
Okay, and then ma'am, let's move on from there. On January 10th of 2023, you live in an apartment complex, correct?
Yes.
And did your landlord contact you on January 10th?
Yes, she did. She contacted me at work.
And what did she contact you in reference to?
She contacted me telling me that I needed to come to the buildings. My little sister observed him wiping feces on the wall that morning.
Okay. And was there a video that your landlord showed you?
Yes.
And what did you see in the video?
It was Daniel with his black jacket on and his book bag.
Okay. And where was he?
He was in the laundry room.
Of your apartment building?
Yes.
Okay. And again, Mr. Black, does he live in that apartment building?
No, he used to stay in this building. That's how he have keys to the building.
Okay. But at that time, he had no business being in that building.
No business. Nope.
Okay. And you saw him on video in your building?
Yes.
And
my little sister seen. I'm sorry.
No. And when was that video taken? Was it taken that day or the day before?
No, it was taken that day, that morning.
that morning. Okay. And then on that same day, a little bit later, did you have another situation where you saw Mr. Black?
Yes, he pulled up at the store across the street from my job twice.
Okay. And how close is that store? Where do you work in relationship to where Mr. Black lives?
I work far away, like he shouldn't have to come to that store.
Okay. And he's aware that you work. How long have you worked at where you're currently working, ma'am?
4 years. He knows my schedule.
Okay. And so what kind of store was across the street from where you work? Was it
It was a gas station.
okay. And so there are it's not like a particular store that he can't only get whatever he may.
No, he's passing by several stores to get to that store.
Okay. And it's
Several
not
gas stations.
that carries something specific that he needs.
No.
Okay. All right. Your Honor, I don't have any questions in regard to the violations at this time.
Okay,
For this
Mr.
witness.
Black, do you have any questions of the petitioner?
I'm at a loss, sir. What
Well, Mr. Jordan has asked, did the direct examination. You have a right to cross-examine Ms. Johnson if you have any questions about anything she's testified to.
okay. So that's a prosecutor or I mean a lawyer in the case.
That's a prosecutor, yes.
Okay. So that's the prosecutor in this case
Yes.
on her behalf.
That just questioned her, correct?
So basically you're asking if I can ask her any questions on what.
I'm not asking you. You can ask questions if you have questions to ask.
Oh, I'm just, well, I'm at a loss because I'm at, yes, the question I gotta ask then is there any video proof of all these accusations? Or is it just basically off of what a person says?
I don't have video proof, but I have witnesses that was there. And they are all here now.
Okay, so the witnesses.
The only video that I have is when my tires were slashed the first time and your sister's vehicle was on camera and someone getting out, slashing it. And I sent that to the judge.
Okay, then, Your Honor. These are
Don't argue to me, sir. This is the time to ask questions. If you have no questions, then we'll conclude that.
okay, that's what I was just gonna get to then. If these are the allegations that she's putting against me, then I have no further questions. We can get to my we
Okay.
could, I don't know.
Okay. Okay, Mr. Jordan, are there any other witnesses?
I don't believe we need other witnesses at this time, Your Honor.
Okay. Do you have any witnesses or any evidence to present Mr. Black concerning the violation?
Well then, yes, sir, I do. Well, I gave you all my evidence. First of all, my evidence is all the
Okay, if
police
you have
report.
evidence, reference what the evidence is, sir. Some of the stuff
yes,
you
sir.
sent to us, you sent us some videos. We weren't able to find anything on the videos. And I think we had you resubmit some other documents as well, but you're going to have to bring those up at this point and reference those because court's not going to search and produce any evidence that you had.
Yes, sir. I want to say it should be exhibit. It should be either exhibit G or exhibit H of the police reports.
Okay. I'm not going to introduce any police reports, sir. So If you have other exhibits, et cetera,
Well, I didn't know that. I didn't know because that was the exhibits, because everything that she stated on there was all accusations, nothing actually seen me do nothing. And
okay,
the only two times that she actually had witnesses that said they seen me do something is the time where I actually gave you the video. I gave you the video footage for January the 10th,
I mean,
where
that's not the date we're talking about.
ma'am, it's not your time to talk, so please be quiet.
is January the 10th is when she said that she had witness, her sister was the witness of me being at the building. And as for, and it was at what time in the morning, because I showed, oh man, I want to say it should be exhibit Z, my time clock record for when I was at work and when I clocked in and out at work on the 10th.
Okay. And what exhibit is that?
I didn't actually have it wrote down on me. It should be, I'm so sorry, sir. Hold on, sir. I could pull it up right now. I can let you know.
Please do so, because I can't guess at what it is, sir.
Yes, sir. I understand.
Jesus, it's exhibit G. It's not E or F.
Yes, because exhibits, the one that I sent you that was exhibits E and F.
I don't care about that now. You're trying to do G,
okay.
so we'll address those later if you want to get into those.
Yes, sir. Well, exhibit G should show my time out, my clock in and clock out sheet.
Okay.
Well, this is my clock in, and this is from my job. I Stanley, if you see.
Yeah.
Can you see it, Judge?
We can see it.
Okay. And we go down here to the 10th.
Okay.
And that is my schedule. When I'm supposed to work, I supposed to clock in at 10:30. I mean at 10 p.m. And I wasn't supposed to clock out till 6:30. My actual, I clocked in on the 10th, I clocked in at 9:55, and I didn't clock out till 6:32 a.m.
Okay.
Okay. So that shows I was at work from that point in that time, Your Honor. And now, since I'm able to show my screen, since you say you wasn't able to see the video that I was able to send you.
Okay, hold on, sir. Hold on. Do you have any questions of the petitioner?
What?
Ms. Johnson, she had testified on direct, and I'm just asking you if you have any questions for her. We've got to get through it one stage at a time, and it's getting confusing by
okay, then
jumping
I
back
understand.
and forth.
Okay, yes, sir, I understand now. So I'm asking the petitioner, at what time was on the 10th that this situation supposed to have occurred, that I was at the building that her sister seen?
Yes. From my understanding, it was around 6:30, but like I say, I could be wrong. Because like I said, I wasn't there. So I'm not sure.
Okay. Around 6:30 a.m., p.m., what?
AM.
Okay. So your Honor, she said it was around 6:30 a.m. We see I didn't clock out from my job until 6:32 a.m.
But like I was saying, I can be wrong. That was just my guess.
Okay.
Okay, then, Your Honor. Well, then, just to justify it even more further, I did send you these videos as evidence, but you said y'all wasn't able to pull it up on the flash drive. If y'all, I can still show you that video, and you can drag through it to where you can see I have 4 cameras that are set up on my house, Your Honor, to where the 2 cameras on in my front yard was.
Okay,
see
sir,
when you could-
let's address this first. Do you have any more questions of Ms. Johnson?
Not in the fact of with this, or.
Okay, you either do or you don't, sir, not,
Okay, my other question is, on that same day, I was, your boyfriend, did a PPO saying with you, and you're saying that he was also one of your witnesses to say that he seen me that day also at the gas station, and I drove by your job multiple times that day. At what time could you give a time about that I drove by your job that day?
It was between, this time when you was at the store across the street.
All I know is you have paperwork on your violations stating on the 10th that you and your boyfriend seen me drive across at that gas station multiple times.
It was me and several people. We even got pictures of you in my phone. I should have submitted that too, but I wasn't really thinking about that day specific.
okay. Ma'am, he asked
My
you what
day is-
time? Okay,
Between
that's the-
8:30 and 9 o'clock.
Okay,
8:30 and 9 o'clock. Okay,
Yes.
well, since that's being since that is being said, like I said, Your Honor, I have video evidence to prove that on that day, once I got home off of work, my car pulled up in my driveway at 6:50, at 6:49, 6:50 in the morning, sir.
okay, sir,
I
you'll have a
never-
chance to
This
present
was
that
he-
when it's your time to
I'm
testify.
sorry. This
Okay,
was
then,
8:30 to 9 o'clock PM, not in the morning. I don't work mornings.
Yes, I understand. Yes, I understand.
Sir, just ask any more questions you have.
Well, then, I don't have no more questions, sir.
Okay,
I have no more questions.
okay. Mr. Jordan, do you have any redirect?
Ma'am, you state that you have pictures of him going past your work?
No, I have a picture of him at the pump across the street at the store from my job.
Okay, and is that on your phone at this time?
Yes, it is, but I do not know how to do that screen share. Let me share the ones that I actually just had downloaded to my phone. Because all of my photos is in my Google photos.
Well, if we don't have it, Mr. Jordan, please move along.
All right. And you said that was
Yeah.
that was in the evening that you saw that, is that?
Yeah,
correct?
8:30 and between 8:30 and 9 o'clock, because we were just closing up the store. I have a witness to that also, and I also had another witness, but her mom had a doctor's appointment today, so she couldn't make it, but she was here the last time.
Who was with you at work who witnessed it?
My manager, her name is Elizabeth Taylor, and it was several other people that were there, but she was the main person that was going to be a witness for me. Yeah, she's the one that took the photo for me and sent it to me. Because, like I say, when something happened, I don't think about my phone, grabbing my phone and video and pictures. But she got a chance to get a picture for me that day, and she's the one that sent it to me.
All right, thank you. I don't have any other questions for this.
Okay.
one.
Mr. Black, any other recross?
No, sir, I don't.
Okay, thank you.
And then,
Mr. Jordan, any other witnesses?
yeah, is Elizabeth Taylor with you at this time?
No, she was the one, she had to take her mom's to a doctor's appointment today at 11, so she couldn't make it.
Okay.
I have witnesses from the day that we caught him slashing 2 of my tires.
What is the person's name who saw him?
I have my boyfriend, which is Devontae Hightower, and his mom.
Okay. Your Honor, I'd call Devontae Hightower at this time.
Okay.
And do you know Daniel Black?
Yes, I do.
How do you know Daniel Black?
I know Daniel Black through my girlfriend.
Okay. And have you, outside of today, have you met him before, saw him before?
Outside of today,
Yeah.
yes, I have many occurrences with Daniel Black, with him following me, busting my windows, spray painting my car. I put a PPO out on him.
Okay. And then was there a time when you were with Miss Johnson and you saw Mr. Black near her car?
Yes, sir.
And was that on January 9th of 2023?
January 9th. I don't know if it was January 9th. I'm not sure. Yeah.
Was it about a month
No,
ago?
no.
When did you
Hey,
see
hold on.
Mr.
He
Black?
talking about the tires being slashed when he came to the house. It was the 30th, December 30th.
Okay. So back on December 30th of 2022, were you at your house or where were you?
And we was at my house. We had just clocked out of work, pulled up. I seen him drive by. I was looking out the window because he's been constantly slashing tires. He's been constantly doing all this. So we came to my house on 170. I seen him drive by, and then I seen him drive by again. Next thing I know, he was in the yard by my girlfriend's tire because I parked the car in my yard because he constantly is slashing the tires. He's constantly vandalizing
Let's just
stuff.
talk
So
about what.
yes, that's what I'm talking. Okay. I'm talking about this event. So he's constantly going through it. So I parked the car in the yard next to my house. I see him. We hear the tire pop. Boom. I see his head stick up, look dead at me, and take off running towards Warren Street where his car was parked. His door was open and everything. He hopped in the car and turned on South Avenue. Turned right on South Avenue. I started chasing after the car and everything. And he turned left on Dickman. Went straight down Dickman. Meanwhile, while that was going on, I called the police and informed them on what was going on while it was going on.
Thank you. I don't have any other questions for Mr. Hightower.
Okay. Mr. Black, do you have any questions of Mr. Hightower?
Yes, sir, I do. Mr. Hightower, you're sitting here stating that right now, sworn testimony that you've seen all this. You're testifying that
Yes,
you've seen this.
Yep. I seen this. I seen you look dead at me. I seen you pop the tires. I seen you run to your black Audi and hop in the car and take off and leave. Yes, I chased you. You look dead at me. I look dead at you.
Okay.
You was wearing a black hat and coat, all that. Yes.
Okay. And so with that being said, sir, I'd like to ask a question then. You also, since you I don't know if I could bring it up, but I think you brought it up, so it should be okay. You said you also have a PPO order against me too?
Yeah, I sent
Yes,
it
Your
out.
Honor, I would
Everything.
just ask the relevance of this.
Yeah. What's the relevance, Mr. Black?
Because the relevance is because on his PPO order that he also stated on the 10th that he seen me also. And that's what I'm saying. Everybody keeps stating that
Mr. Black, you can ask the question.
The reverence of it is the fact of it is you're stating that you've actually seen me. You actually seen me on the 10th.
I said it was the 30th. We're talking about the 30th. I seen you on the 30th.
I understand that. Yes, sir.
Yes, I seen you. No. I don't know.
Mr. Hightower, Mr. Hightower, stop.
Okay, hold on. I'm sorry.
Stop.
I'm sorry.
Wait till I ask you the question.
Yes. He said the question, if I'm correct, right? You asked was, did I see you on the 10th?
That's correct.
Yes, sir.
Right, because I guess he said I made it. So what was it? The feces. Oh, yes. Across the street from the store when he was at the gas station. Yes. He pulled up at the gas station. He pulled up on one of the pumps at around 8:30 something. Yes. And then he pulled off. He went in towards the store. He went, patted his pockets and stuff. Looked like he forgot a wallet or whatever. He forgot something. I don't know. It just looked like he misplaced something. Hopped back in his car, took off, going back down 20th Street towards Dickman area.
Okay. Next question, Mr. Black. Hold on. Don't have a question. Go ahead.
All right, so that right there, because Your Honor, because I have no further questions because you just
Okay, if you
stated.
have no further questions, then stop. Okay?
Yes, sir, I have no further questions.
Okay, any redirect, Mr. Jordan? Any additional witnesses, Mr. Jordan?
I guess I believe I may have some police officers. I don't know if I could have a brief recess to speak to them in a breakout room. Just to see what they saw and heard.
Okay, I'll give you 5 minutes, but we've got another hearing that we're got to get through too as well.
Okay.
So,
I was just
Yeah,
gonna ask a
I'll just
question,
take
sir.
a couple minutes.
When will I be able to get about the video footage to show that I was at home all day?
okay, we'll wait. When it's your time to testify.
You know, I don't be late. So. And guess what? I told her that. It's like when I said she wasn't know I'm not gonna go like, girl, you.
Ma'am, if you're gonna talk, mute yourself, please.
Sorry.
Thank you. And where are you employed, ma'am?
Battle Creek Police Department,
Okay, and your position there?
road patrol officer.
Okay, and were you working in that capacity? I believe it was on December 30th of 2022.
I was.
All right. And did you get called to a complaint by Miss Johnson?
I did.
And what was that complaint in regard to?
It was in regards to a malicious destruction of property where she stated her tires had been slashed.
Okay, and did she state who she saw caused the property damage?
When I made contact with her, she said that she was inside of her residence, and she saw Mr. Black's black Audi pull up. He got out of his vehicle, slashed the 2 tires, and then took off running back towards his vehicle, where he then left the area.
Okay, and in response to that, did you try to make contact with Mr. Black that evening?
I did. I attempted to make phone contact with no answer, and I drove to the address we had on file, which was the last known address we had for him. His vehicle was not parked outside, and we did not make contact with him there either.
Okay, was that on a?
Yes. Yes.
Okay, thank you. I don't have any other questions for this witness, Your Honor.
Okay, Mr. Black, do you have any questions of Officer Dellinger?
Yes, I do, sir. Ms. Dillinger, you stated that you tried to make contact with me that night by telephone.
Yes.
Okay, for the records, could you give me that telephone number, please?
I don't have that phone number on me. It's just whatever was in our system at the time of the incident.
Okay, then, because with that being said, I have no records of you calling me that night.
Sir,
And
this
that's-
isn't your time to testify. It's your time to ask questions.
Okay, yes, sir. Well, then my next question then is, you said that you came to my address and my car wasn't here.
Correct.
Okay, so when you came here, there was no car in there. There was no car at all parked in the driveway.
No.
So you did not see a 2009 silver Impala parked in the driveway.
To my knowledge, I don't remember any vehicles being in the driveway, but in specific, we were looking for a black Audi.
I have no further questions, Your Honor.
Okay, any redirect, Mr. Jordan?
No, I'd like to thank and excuse Officer Dillinger.
Thank you, Officer Dillinger. You're excused. Have a good day.
Thank you, you as well.
Any other witnesses, Mr. Jordan?
No, I would like to call Elizabeth Taylor, but obviously she is unable to be here at this time. I don't know if the court would entertain a motion to adjourn to allow her to testify.
What is your response to that, Mr. Black?
For waiting for her to adjourn for the testimony.
Mr. Jordan wants to adjourn the matter, so we'd have to adjourn it a week or two.
No, sir.
Okay. Well, the court has had this matter back before the court twice before, Mr. Jordan, that we've adjourned to accommodate the parties, so I'm not gonna adjourn it any further, so.
Okay, thank you. I don't believe I do not have any other questions at this, or witnesses at this time.
Okay. Mr. Black, do you wish to render testimony at this time?
Yes, sir, I do.
Okay, you're under oath, so go ahead and tell me what you'd like me to be aware of.
Okay, well, first of all, like I said, I gave you the video evidence.
Well, do you have it, sir? Do you have it on your,
Yeah,
where you could share it?
yes, sir, I can share it. Like I said, only thing to be so you can, because it's a video footage of from my whole day, sir.
Oh, okay.
So I can share it, but then I can like drag it to where you seeing that is no skipping. It's just showing you the complete day within that whole day, where you see where my front door doesn't open, and then I can show where my back door doesn't open.
Okay.
Until the police get here that day. And these are the days.
Which day was that, sir?
This is January the 10th, sir. The day that I'm accused of being at the property, and the day that her witness.
Sir, the date of the property was December 30.
No, not that. No, the date that she's talking about is at the apartment at her boyfriend's house. They have no video evidence of that day of them
Correct.
saying
Correct.
of them saying that. It's only speculation and hearsay, because it's like this right here.
It's testimony, sir.
Well, yes, you're right, sir. It is testimony, but I'm here to prove that their testimony is poisonous, is fruits of a poisonous tree.
Okay, well, let's address the December 30 date. Do you have any video for the December 30 date?
No, sir. If I would have been fully aware of this prior to that, because my video cameras only record, it only holds 10 days worth of footage, then it rewrites over itself, sir. If I was prior, if I would have knew prior, I would have got that video footage.
The answer is no. The answer is no, sir. Correct? Okay.
No, sir.
Okay.
This is the video of my back door, sir.
Okay.
And if you see, it's at 6:49, January the 10th. And I'm finna drag it so you can see that my car is gonna pull. You see my car pulls in. That's me getting out my car at 6:50 something. And then as you see, I go in, and as it drags, I do not leave my house all day. My car stays in that spot. And this is my back door. And this is the 10th, where they say they seen me at that building and seen me driving past her job multiple times. And my car never leaves. My Audi is back. My Audi is inside the garage. It is 9 o'clock right now, sir. It is 9 o'clock. And now you're finna see, that's when I cranked my car up at 9:37, right before I get the phone call from the police officers wanting to come to my house to look at my video camera. That's when I leave. At 10, I'm late for work because I leave after. This is a video of my front door of when I come home, sir. So you can see the front door of my house. And I never leave out my front door. As you've seen, I never left out my back door. And this is me pulling up at the same time. January the 10th at 6:50 in the morning, sir. This is me pulling in. And now this is video throughout the whole day. I never leave. Nobody comes inside or outside my house all day. That's a video.
Okay, go ahead. Any other testimony, sir?
And the only other thing is like what I had said when he testified about that's why I'm saying that he's saying that he's seen me.
Okay, you have to identify who he is, sir. We're making a
yes,
record
sir.
of this.
My apologies, you're right. Mr. Hightower said that he seen me also, and he got some PPO order statements, and that these are all lies because he's making these statements saying that he seen me on this day, and I just showed video proof. No one could have seen me that day. No one, because I was at my house that whole day. Saying that they seen me, they saying that they're telling a lie. If they're saying they seen me on that day, they're telling a lie, and they all just testified under oath that they just seen me on this day at these times.
Okay, anything else, sir?
No, sir. That's all my evidence that I have.
Okay, Mr. Jordan, any cross?
No, Your Honor, I don't have any cross for this one.
Okay. Thank you. That looks like that concludes our evidence at this point. Mr. Jordan, any closing argument?
Your Honor, in regard to this case, we've had two witnesses testify that on December 30th, 2022, that Mr. Black approached Ms. Johnson's vehicle. Ms. Johnson obviously testified that she heard a popping sound and saw Mr. Black running away from the car. Mr. Hightower said that he heard the popping sound, made eye contact with Mr. Black, who then jumped into his car and left the scene. Police officer Dillinger reported that she went to the house later after that. Obviously did not have any contact with Mr. Black. His vehicle was not at the home, the Audi that they were looking for. And so I believe petitioners met their burden in regard to that violation. In regard to the 10th, where we just saw the video shown by Mr. Black, he arrives home at 6:50 a.m. Violation 4 in the petition states this happened around 6:30. There is a 20-minute gap between when he punched out of work and when he got home, that he could have went through and done this at that time. Again, there's the other violation of across work. We had a witness who took a picture of him at the gas station across the way from him, but was unable to testify. Again, while his car was there, and he shows the two different perspectives, they were scanned through quite quickly. But I do believe he's violated this PPO multiple times in multiple ways, and we're asking the court to hold him in contempt for violating the PPO at this time.
Yes, sir. My closing argument is that the state hasn't proven without a reason. The prosecutor hasn't proven, having given no physical evidence to prove any of these allegations to be true. The witnesses that they're using is showing that their testimony is fruits of a poisonous tree, because I showed that there's evidence to show that I was at home on the days that they're accounting me for, and then for them to sit there and try to use a witness that wasn't even here that I could even face is unjustifiable. Everything that the prosecutor has used is all under speculation. There's no surface evidence, as in I have shown concrete evidence of my clock out of when I was at work to where they're saying that I was doing this stuff. And then when I was at home, from the times where they're trying to say that I was accused of this stuff. And just like the prosecutor just stated, that there's a 20-minute window that I could have allegedly done this from the time that I clocked out, is actually false statements on the prosecutor, because I clocked out. If I clocked in, if it's shown at 6:50 me pulling at my house at 6:50 and I clocked out at 6:32, that means it's only an 18-minute window. And that means I had to drive from my job, I Stanley, to her house on Gowag Street, which I could pull up right now because I already did it in Google Maps, and will show you that it will take exactly 19 minutes for me to go from I Stanley to her job, and from I Stanley, from my job, from I Stanley, my job, to her apartment building, from her apartment building back to my to my house. That is travel time of 19 minutes. It is travel time. That is not including the time that I had to actually go inside of this building that they're claiming that I did this in. So yes, you cannot sit there and you cannot use that of a time, that little brief window period. That's the time frame that I had to drive from work to home. So all I'm saying is, all I'm going to close this on is that the prosecutor has no physical evidence that shows that I have committed any wrongdoing on this PPO violation. And I have showed that I have did everything within this PPO that shouldn't even be against me right now. And I end with that, Your Honor.
Okay, thank you. Mr. Jordan, anything else?
Well, yeah, Your Honor, he did skip over the 2 eyewitness accounts in this matter, and there was no evidence placed by him as to how long it takes him to drive from work to home. I'll just leave it at that.
Okay. Well, the court is cognizant of that. The court does note that obviously it would take him some period of time to drive home. The court can take judicial notice of, again, I Stanley, where it's located in Fort Custer, and his address that he's identified in these proceedings. We're looking at really at 2 dates, the December 13, 2022 date and the January 10th, 2023 date. And obviously the respondent has produced, again, the video evidence that we were able to see, seeing that he did not leave his house on that date, notwithstanding the testimony of the petitioner and Mr. Hightower as well. The court will note in this particular matter that the testimony on the 30th, on December 30th, is different. There was direct eyewitness testimony from those individuals, but the court does note that in every case, credibility is an issue. And court notes that simply when people testify, oftentimes their testimony is, I guess you say, impacted or influenced by their bias, prejudice, understanding, misunderstanding of the facts. And the court doesn't infer that a person who testified wrongly is trying to lie, but notwithstanding it, they may have incorrect testimony. In this particular matter, we have testimony that directly that Mr. Black was at the Mr. Hightower's home on the December 30th date, and that Mr. Hightower also testified that he saw him on the 10th when he was apparently across at a gas station across from the petitioner's work, and the petitioner had testified as well that Mr. Black was at that gas station across from her place of work on that date as well. When the court looks at all of the evidence in this matter to find the respondent in criminal contempt, the court would have to find beyond a reasonable doubt that he in fact did the alleged offense. If it's civil contempt, it's by clear and convincing evidence. Based upon the testimony and the contradictory testimony, the court cannot find that Mr. Black was guilty of criminal nor civil contempt in this matter, and as a result, the court is going to deny the petition in this particular case. I would note that again, there was no prohibition on Mr. Black being at the gas station on January 10th, 2023 in any event, because the PPO provides that he can't be on property owned by the petitioner, by leased or occupied by her or at her residence. It does state that the can't appear within her site, but appearing at a public place does not, again, infer that he was within her site at that particular time. So as a result, the court will deny and not find Mr. Black in contempt of court. That'll be the ruling of the court. We'll conclude this matter at 12:23 p.m. You're free to go. Have a good day.
Thank you, Your Honor. So with that, is that all of it wrapped up, Your Honor?
Oh my
That's
God.
it, but the court is going to keep the PPO in place and tell you, Mr. Black, make sure that you do not violate that in this particular case.
So my motion to terminate the PPO
Is
so
denied.
the-
Is
is
denied.
denied.
I'm keeping that in place.
Okay, but
Mhm.
the motion to show
The
cause
violation.
is thrown away.
Yes, correct.
Thank you, Your Honor.
Okay, thank you. You have a good day, both of you.